Welcome, everybody, to AIB Radio, County Assemblies, Jean Blaine and Maria Janet. This 23rd day of April 2011 for our webinar. Take it away, Jean.
Okay, we're going to go over, there seems to be a lot of confusion about the capacity in which these judges are acting. All these judges, all of these people in the public domain are acting as trustees. They're dead. Write this down. In fact, you need to look it up in Black's Law Dictionary. What a debtor in possession is called. You got to know who you are, and you have to know who they are. Otherwise, they're going to run right over you. They're acting as debtors in possession under a Chapter 11 reorganization, acting as trustees to the bankrupt estate. They're bankrupt. That's why they need you to pay their bills. That's why they send you a bill each month. They're using your credit, and nobody seems to. Everybody tells me they understand redemption, and yet they don't. They don't know how to do an acceptance or a money order. Convert a bill into a money order. You convert it into a money order by doing pay to the order of. And when you do that, it becomes a money order. And you have to do this for each bill. I don't know why I'm getting a converter. It says converter did not save this.
Well, you have to go back in and pull it back up and get us going. I want to also let our students know that Jean got behind on a few things and didn't get the attachments out, but we'll get them out hopefully either later tonight or as soon as he can get them to me.
What is a converter?
Converter?
Yeah. Backup of pay to the order of. Here it is. Okay, this is how you're supposed to do a pay to the order of. This is pay to the order of the U.S. Department of Treasury.
Pull it over to the left a little bit, Jean. Your screen is off to the right. So that we can get a good screenshot of that.
Can you see it now?
A little bit. Well, I think, there you go. Now I can see it.
This is what I paid an $80,000 court judgment off with.
Explain the red postage stamp private use. Was that on the envelope that you received with a red
Yep.
meter?
They're using these prepaid red seal stamps. They're using the mails as a private debt collector. It's not the it's not the banks that are foreclosing on you on the American people. It's the attorneys. They're acting as private debt collectors, and they cannot do that. Congress revoked, in 1986, they revoked their exclusion. They're excluded from being a debt collector. But if they're collecting debts, they were abusing their discretion, so Congress revoked the exclusion. So now, if they collect any debts, they're acting as private debt collectors. They're governed by the provisions of the FDCPA, Fair Debt Collection Practices Act. And they have to, once you challenge the validity of the debt under 1692 G, small g, and 803, they have to stop. They have to cease and desist all collection. That's why you people are losing your properties. You're not challenging the validity of the debt. So the assumption is that that you owe the money.
Okay.
Nobody challenges anything. And you can also challenge the authenticity of the signature under 3-308 of the Uniform Commercial Code, which says if you don't challenge the validity of the signature, the validity of the signature is admitted. And you can do it under the best evidence rule. All states have an evidence code, and the federal rules of civil evidence has their own evidence code. And I think it's 1101. It's called the best evidence rule. A copy is admissible unless you challenge the validity of the document. If you challenge it, they have to produce the original document, and nobody's doing that.
And that would be on the foreclosures.
Yeah.
But would that play into any court orders?
Yeah, you could challenge. I would. These courts are acting as private. The judge is acting as a private debt collector.
When they sign the orders.
Yeah. Aren't they doing a taxable termination? Go read 2603. Maybe we need to go in there and review that. Anytime you terminate somebody's interest in property, it's a taxable event. And the person that's liable for the tax is whoever does the termination. The trustee is liable for it. And they're acting, that's why you have to appoint them. If you have to use a Form 56, do it. But you can do it orally. You can do, and that's what this is what I did on this. I had a $73,000. You can see it, $73,137. I said, charge the sum said, pay to the order of U.S. Department of the Treasury, $73,000. And I charged it to the attorneys. These are the attorneys. There's their state bar number, and there's their address. There's their telephone number. And then I put "and facsimile" and credit the memory of my Treasury direct account, which is the Social Security number. Now, you can use the red number on the back of the Social Security card is a private account number with the letter in front of the red number designates which bank your account is drawn on. Now, you can put that bank down there. You can put that number down there.
What if your Social Security card has a blue number on the back?
I've never seen one with a blue number.
Okay, well, some of the older Social Security cards, when we started getting Social Security cards, they didn't even put numbers on the back of them. And then they put blue numbers on the back of them, and now they put red numbers on the back of it.
The red means private, just like red ink. And I did all this, and I wrote this out in red ink. I didn't type it. I wrote the whole thing out.
So you hand wrote it on the thing?
On the order for judgment. They ordered, saying this is a sanctions judgment against me because I didn't appear at the court hearing.
Is it better to handwrite it than to type it?
I think it is. That's what I'm just telling you what I did. I wrote everything in red ink. All were originals. I wrote them in red ink and signed them in red ink. And I also did this postage thing, and I never heard from them again after I did that. I think it's funny.
Okay. So if you've got some kind of an order that doesn't have a final figure on it, like court orders,
This was a court order. I put this on a court order, and I sent it back to the judge. I sent it to the judge. I didn't send it to the court. I sent a copy to the judge because he's the one that issued the order. And that's a taxable attorney's fees, and I got a letter somewhere on my computer here. I've got a letter to Diane Stanfield. Let me see if I can find the letter. I sent a letter along with this telling them that this was a...
Okay, we have a question on the board that says, my number is black on the back of the Social Security card.
I'm getting this converter thing. I don't know what's going on.
Okay, so how about court-ordered probation? Wouldn't you just send that in with a letter saying, I don't know what the total amount is, make it correct and let me know what I have to do?
Well, yeah, tell them to send you a bill.
To the probation officer.
No, send it to you.
Right.
Have them send the bill to you.
Right, the probation officer send a bill to me.
Yeah, you can't. They can't. They don't have any legal authority to order you to pay anything, to pay any kind of.
Yeah, but they don't. They keep you on the line saying you got to go see this probation officer 3 times a week or for the rest of your life, and if you go, they assume that you did child abuse of some sort. There's a lot of people that got caught on that that were set up by the police and everybody bringing the so-called evidence into the house and then arresting you. That happened, in the early 90s. Many people did that, and they were charged with pornography and all this stuff. But and then they got hung with lifetime probation. But there's no figures on a probation order. So how do you pay a bill or get a bill for a probation order that doesn't have any figures?
Well, they're not billing you then.
But if you don't go and see them, you can't take care of the issue. If you don't go in and visit their office, however many times they say, they put your butt back in jail.
Well, here, I'll show you what I did for Roger Elbick. I wrote this for Roger Elbick, and he sent him home.
And he was incarcerated?
Oh, he was out. He was out on parole. He left the facility without their permission. They were going to arrest him.
Yeah.
I don't know what's the matter with this. There's something wrong with my... I wrote him a letter, and they sent him home because I made him liable for all the taxes. Let me see if I can find the letters.
So anybody looking at a possible sentencing of some sort, they could do a similar letter, and it might take away the sentencing?
Yeah, absolutely. If you start making them liable for the taxes, they'll get rid of you. That's why they took me out of their system.
Well, that's like this judge tried to tell me yesterday in my situation that the situation was a criminal charge, not taxes. And I came right back and said, it's a taxable termination. If you don't pay the taxes, you're going to be saddled with the fines, too. I'm going to have to do some reporting.
Ask him where's the corpus delicti, if there's been a crime committed. Ask him who the injured party is. How can the state be both the injured party and prosecute the case at the same time?
Well, that's what's wrong in the entire court system.
Well, that's because it's all private. They got a private claim.
I know.
And well,
I think our listeners would like yesterday when I told the judge that it was that they were making a claim on my estate. And he came right and said, "Not me, she is," pointing to the prosecuting attorney, who almost fell off her chair. It was rather
she got caught with her hand in the cookie jar.
And she absolutely turned every shade of purple you could think of. It was funny. It was really funny. What if while you're bringing up this letter, what if the IRS is saying I owe $300,000 on my name, my business name, and a not-for-profit I created? I do not understand this process. What can I do to answer them until I can understand the process?
Tell them to send you a bill for the tax, and you'll pay it.
Send a bill. So the bills that they're sending out, can't you just use those?
Yeah.
The statements and the charges that they're trying to charge you?
Yeah, you do a pay to the order of, just like I showed you on the screen. Okay. This is what's going on in the courtroom. You have to, I'm going to go through this, and then we're going to post this. This is 127 pages long. Okay. This is called an option contract. This is what the court is doing. They're using your account, your Treasury Direct account, to do a call option. A call is a buy order. What does it say? Read this. You read this. Okay. Definitions. An option contract that gives the holder the right to buy a certain quantity, usually 100 shares of an underlying security, from the writer of the option at a specified price, the strike price, up to a specified date, the expiration date, which is also called a call option. The act of exercising a call option. The right to redeem a callable bond before its scheduled maturity. Can you still see the screen? Yeah, now you got the whole thing there. Number 4, in banking, a demand to repay a security loan immediately. This is what's going on in the courtroom. Read what this says right here, introduction. Introduction. Imagine this. You are sitting at the blackjack table and the dealer throws you an ace. You'd love to increase your bet, but you're a little short on cash. Luckily, your friend offers to spot you $50 and says you can pay him back later. Tempting, isn't it? If the cards are dealt right, you can win big and pay your buddy back his $50 with profits to spare. But what if you lose? Not only will you be down your original bet, but you'll still owe your friend $50. Borrowing money at the casino is like gambling on steroids. The stakes are high and your potential for profit is dramatically increased. Conversely, your risk is also increased. Investing on margins isn't necessarily gambling, but you can draw some parallels between margin trading and the casino. Margin is a high-risk strategy that can yield a huge profit if executed correctly. The dark side of margin is that you can lose your shirt and any other assets you're wearing. One of the only things riskier than investing on margin is investing on margin without understanding what you're doing. This tutorial will teach you what you need to know. This is what's going on in the courtroom. Okay, let's take another sentence here. Will they issue a warrant for your arrest if you don't go to a probation thing? Yes.
Okay, so how do you offset that? By sending a letter to the
By
probation?
sending them a letter rogatory.
Letter rogatory. How about your 99A and 99C with the 56?
Yeah.
And an OID, and tell them, so they see their name on those forms, that they're going to be tendered to the IRS if they continue.
You can do a letter. You can do a letter rogatory to the judge. You'll conditionally accept their offer to appear. That's what I did, and we made a special appearance. Toby never went into court, and the judge took the case off the calendar. Maybe we ought to go over that letter.
Yes, it would be wonderful. I think people getting this 127 page will be able to read it when we get it out, hopefully tonight. So are only the envelopes with the red and black meter strips the ones that count, or what if it's just a letter from an agency back to you? And what about anything that's in the envelope?
None of these files are opening up. I got something wrong with my... Go ahead.
It's some things, my phone's ringing somewhere, but it's not ringing here, so I don't know where the
Go ahead. Yeah. Well, you have to register with it. You have to register. Well, I don't know how she's doing that.
If they didn't send me notice of payment, they didn't get approved.
Yeah, I'm right in the middle of it. Okay, now let me call you back. Yeah, he said he didn't get a link or whatever. I don't know what it is he has to do to register.
I don't know who it is. I sent out mass emails, everybody knows. And when I went through the approval list, I sent them an email that I couldn't validate, saying you must validate, you must send me an email validating before you can get approved. We had 10 people tonight that registered but did not send validation of their payments. And all day I've been emailing back and forth to people to get that clarified. Even on some of the older people that I had to re-clarify 3 times because my computer did not lock in their payments. So I had to go back and revalidate, and I do this every week. So if you didn't get on the call tonight, let your friends know that they have to pay Jean at mishnowskitom@yahoo.com through PayPal, and they have to send me validation of that payment, or you don't get on the approval list, and you don't get approved to join the call. Just like this gentleman, this person that just called just now. Let's get back to the subject here. They want to know if you can do the pay to the order of on a record of a tax and on the envelope that doesn't have, it's called record of a tax sale certificate in the county records.
Yeah.
So would you send it to the tax collector who signed the certificate, or to the treasurer of wherever they put that on the record?
You send it to the IRS, U.S. Department of Treasury.
Yeah, but don't you give a copy of it to whoever signed it?
Yeah, you send a copy of it to whoever sent you the bill.
Yeah.
We went over that last week.
this person is trying to say, because they're not sure because it's just on the county records. And would that be the person who signed the certificate or the treasurer? Because the treasurer did not sign it.
You pay the IRS.
Right, but you send a copy of that. I would say send it to the treasurer and to the person that signed the certificate.
We gave out that 0-year account to everybody on the class last week.
Right. It went out. So you got to read that. Gene cannot make his screen any bigger than what it is on the screen. We're doing screenshots. We have one of our class members that's going in and pulling everything that Gene shows us and putting that in the attachments that you guys are getting on the screenshots. Could Gene briefly explain how to? He's gone over the pay to the order several times. Go get the 0-year account. If you don't have it, let me know and I'll send it back out. To close the property count with the county property. How many times did Gene have to tell you? We went over this on 4/2, I believe it was, 0-year account. We spent almost the whole webinar on that publication.
For some reason, these files are not opening up. I must have a virus on my computer.
To get a red number on your Social Security card, do you have to get a new card every 7 years?
No. I haven't seen a card without a red number on it.
Okay, someone gave a bank CEO a 4490 blank 4490 form, and the CEO sent him back a letter that said, "We do not see any connection between this form and your transaction with the bank." It was for a home equity loan. Well, evidently their legal department didn't understand not paying the taxes is quite devastating for them. So would you, Gene, supply them with the OID 1099A and 1099C and reattach the 4490 form?
Yes.
Okay, there's your answer, folks. Sometimes when they see their names on those forms.
For some reason, none of these files are opening up.
Well, you had one just a minute ago.
Well, they're not. This one I wanted to show you, the letter rogatory.
Well,
You've got a copy of it. Why don't you send it to me?
You've got letter rogatory to the judge there on your screen.
Yeah, but it won't open up.
But I don't think do. I have an,
I sent you all that material.
okay. To the judge, okay. Maybe you just need to go and reboot your system and then come back on and we'll just have conversation and questions.
Well, it's not going to disconnect if I reboot this, is that going to disconnect me from the,
No, because your voice will still be here, but you have to come back on in order to be the presenter. You can change presenter back to me while you're rebooting.
I don't know why this letter is not opening up.
So, was that the letter to Judge Worley?
Yeah.
Okay, so I'm going to make a note for letter, Judge Worley. Worley, W-O-R-L-Y. Okay, and that's letter rogatory, so I can send that out because I now that it's been identified. I'll make a note, send out tonight. Okay.
I don't know why this thing's not opening up.
So your letter derogatory would be, for Elvick, the example would be a good one to start with for people that have friends and people that are incarcerated or that are on probation.
Well, I got to find it here, and it's not coming up.
Okay, folks, this is a good time to put your questions in so that Gene can be answering while he's looking. I think the biggest thing that everybody can do if they're in a courtroom setting is just continually let the judge know that you're there as a representative of the estate, and all you want is the bill so the estate can pay the bill. And every time they try to tell you it's a criminal charge or it's this or it's that, it's still a taxable termination event. So if you continually accept what the judge or the prosecutor or the attorney is saying under a conditional acceptance upon proof of claim that I'm not the representative of the estate and that you do not have to give me a bill when I ask for it so the estate can pay the bill. Is that a fair statement, Gene?
Yeah.
Okay.
It says the converter failed to save this file. I don't know what that is. I'm getting it on all these.
You better just shut your machine down. Because it sounds like you're going to corrupt a whole lot more. And hope you have it backed up. We're waiting for questions, folks. This is your time for questions. I don't see any questions on the board. Are you still with us, Gene? Okay. I think we've lost Gene. Let me see. He has to come back in. And I'll have to make him a presenter again. So while he's doing that, put some questions on the board. I'll see if I can forge a few of them, and then we'll have them revalidated with Gene when he gets back on, because he's not on right now. Let's see if I can put him on the attendees. See if we can get. He's not on here yet again. Okay, we don't have Gene on. He's got to come back on. He knows he's got to come back on. Let me see if there's any more questions. Where's my question thing here? I have lost the questions. There's a chat that, oh, here's questions. Let's see if there's any more questions. The last one was an equity home thing. That's the last question I had on the board. Can everybody hear me? Give me a chat, give me a question. If you all can hear me. We need clarification regarding zero out the account. Item 3 creates confusion. Who gets what when originals or copies of the forms, bill, money order? Page 9. Okay, we have to go over this when Gene comes back on. Now that you've typed this, what he's telling me, and we do have to come in and clarify because this says send the original to the person that gave you the bill, which is what Gene is saying, and zero your account is saying put the original to IRS. So we have to go back and clarify that with him again. Thank you for your comment. We're waiting for Gene to get back on. Let's see if I can call him on the phone. Well, we might wait just a minute or two because I know it takes that long for a computer to reboot. Send IRS, Kansas City, Missouri, if you live in Michigan. The red OID, the red 96, the 1040V, their offer, and 4A, proposed change of item 3. They, whoever made the offer, gets back a copy of their original bill as sent to the IRS. Okay? 1040B is a copy, 10OID is a copy, 1096 is a copy. The IRS gets the originals. The bill, the money order, the 1040B, the 1099 OID, and the 8281 with the 96. Now, who's ever writing that the 99 OID, the 8281, and the 96 is optional, that needs to be clarified. Because I thought if you're going to do a money order, those forms have to precede it. So some of our older students that have studied with Gene before and I have an understanding of that clarification, give me a chat or give me a question. So let me see if there's any more chats. No chats. Let's go into chat. The chat's knocked out my questions. So I'm going to go back to questions. I'm having fun with this. Let's see where Gene is tonight again. All right, I think I'll give him a call, so everybody just hold on a minute. Hi, how you doing with rebooting that? Okay, well, you still have to come back on now. With the computer on, you have to rejoin the webinar so I can change presenters again. You have to go click on it and come back in as an attendee so I can get you on as a presenter. All right. All right, the students are waiting, so I'm just letting them hear that you're getting that up there again. So, okay, Jean is attempting to open up the files right now, students. Just kind of hang with us. So however much time it takes, we'll extend the webinar time tonight to make sure that you get your full 2 hours. There were some, let me do this way. There were some questions on the board, Jane, about inconsistencies with the zero-year account. One page says to send the originals to IRS. Another page says send the originals to the person that sent the bill to you. There's a little bit of confusion. And there's...
Well, excuse me. I told you, we went over this last week. Okay, I got the letter open. It's opening up now.
All right, now come back on. I'll drop off the phone and wait for you to get on, link back on to the show as an attendee.
Okay, I got to go back into Yahoo then, right?
Yeah, you have to use that email link.
This letter is important. I got rid of 2 cases.
All right.
Alone cases.
All right, the people are waiting on the line right now, so I'm going to drop off the phone and let you come in back on that email link, and then I'll put you as presenter again.
Well, wait until I get in here.
Okay. Our students are waiting patiently, too.
Okay, Mercy. Join the webinar.
Okay, let's see if we have any more questions.
Okay, I'm back on the webinar.
Okay, let me change presenter. Let me go down and get to the, I have to go in here. I have to find you. You're not here as an attendee yet.
It's on my screen, it is.
Oh, I hear you now. Let's see if I can find you. Down to the T's. Let's see if you're on here. There you are. Okay. Change presenter to you. Okay, I'm going to hang up the phone. Oh, what happened to my whole screen?
Okay. My screen's up now.
Mine is not. I'm going to drop off the phone. Go ahead, Jane. We got you on voice, but for some reason.
Can you hear me?
Yeah, now, yeah, everybody can hear you now. Go ahead. Your screen is up there.
Can you see my screen?
No, it says Dear Jean Blaine. I don't see you. Just a minute. Let me change presenter again. Somehow it's... No, you're on there as a presenter, so no, I don't see your screen yet.
Well, I'm clicking on it. It says show my screen.
There it is. There it is.
Can you see it now?
Now I see this Judge Worley.
Okay, this is a letter that I wrote to Judge Worley.
Click your little button up here to make it the full screen, because we're only seeing a third of it.
Can you see it now?
We only see the top third. You got to click the box up by the X, I think.
Can you see it now?
No.
Well, I don't know what you need to do. You got to tell me I don't know what you're saying.
I see the top third of the letter down to the line Acceptance Corporation.
Can you see it now?
No, just the third, just the top third.
What about now?
No.
Are you there?
I'm here. I don't
Can
know
you
if
see it?
anybody else can see the whole screen. I just see the top third of the letter.
Can you see it now?
No, we just see the top third of the letter. Your file is on top of the other file from Citrix.
I don't know what's the matter with this, why it's doing that.
Well, talk about the letter, because everybody will be getting the letter.
Can you see this letter now?
I told you I only see the top third. If anybody can see the whole letter, give me a question or a chat. Nobody's given me a question or a chat that I can see.
Well, I don't know why you can't see the letter. I don't know what you're seeing. You got to tell me what you're seeing.
I told you the top third of the letter, down to the line that said the first paragraph, Acceptance Corporation, is the last line we see. A corporation here and after infinity and their counsel. That's the last line that we see.
Where is that? I don't even see that on here.
It's on the first paragraph, 1, 2, 3, 4 lines down.
That's not the first paragraph.
It says, Dear Judge Worley, I am writing by special appearance in private in response to this court's recent summons and notice of application for a writ of possession and hearing that I was served on April 7th, 2010. On behalf of Plaintiff, Infinity Financial Services, a division of Nissan Motor Acceptance Corporation, a corporation hereinafter Infinity and their counsel.
Can you see the rest of it?
No.
Well, I don't know. There's something wrong because you could see it last week.
Well, everybody's going to get a copy of this tonight anyway, because I've made a note to send it out. Why don't you just go ahead and talk about it?
Well, go ahead and read it, but you can't see the letter.
No, I can't see any more of it than that.
Well, there's something wrong with your screen then, because this is what we were doing.
Well, it's your screen. I don't have any control. You're the presenter. It's your screen.
Yeah, but there's no reason why you can't see this.
I've asked if everybody else can see it, and nobody's giving me a chat or a question telling me that they can or cannot see it. So in this letter contains, there you go, now I'm seeing more. You got to pull
Can
it
you
over
see
to
more
the
now?
left. I can't, I students can see the whole thing, but I don't see the very right hand of it because the control panel, I've got to figure out
Can you
how
see it
to
now?
hide the control.
Can you see it now?
I'm back to seeing 1/3 of it again. 1/3 of it is what I see. Now I see 3 paragraphs. Okay, so this letter is set up on a retail sales installment contract, right? Now, would that apply to...
Yeah, I asked. This is, you're asking for the note. You should be asking for the contract. You notice I'm asking for the retail sales contract, installment contract, hereinafter contract, unaltered with original signatures.
And that essentially is the application?
You fill out a loan application when you get a loan, whether it's a mortgage loan, car loan, I don't care what it is. You fill out an application. Ask them for the application. Nobody does that.
And what's the relevance of that?
Well, they sold the contract. That's what the relevance of it. If they don't have a contract, you don't have a loan, do you?
Okay.
Well, duh. There never was a loan. That's why they don't have the contract. They sold the contract when there was no loan. Why do you think the judge pulled the case off the calendar? How much of this can you see?
I can see down to number 3. 3 or 4 lines after number 3.
Okay, read number 3.
Okay, that Infinity sign a receipt for the instrument or promissory note for payment made in full as accord and satisfaction under Section 3311 of the California Commercial Code by securitization of the contract under the transfer and servicing agreement, and to surrender the instrument or promissory note to me as mandated by Section 3501 2C, big C, of the California Commercial Code. Okay, so let's apply this information here.
The reason I'm saying this is because the loan was paid in full at closing. FASB number 95 says that. If you go down, finish reading this, I'll go into that.
And that is the same thing as a mortgage loan?
It's the same thing, identical thing as a mortgage loan.
How about court documents?
We're not talking about a court document. We're
Okay,
talking about the contract.
Okay, so that the court document and this is 2 different situations.
Just go ahead and finish reading this, and if you got any questions, I'll answer the questions.
Okay.
Just finish reading this.
Okay. That Infinity produced the scheduling balance sheets, RC-C, showing loans and lease financing receivables or assets, and RC and L call reports evidencing securitization of the retail sales installment contract as an off-balance sheet item under the transfer and servicing agreement, and the accounting ledger for the above alleged automobile loan transaction to show that Infinity is in compliance with FASB Financial Accounting Standards Board number 95 statement of cash flows and credited my payment as a cash deposit and receipt as the payer when the entry was made under sections 1813 1,
That's L. That's
L1,
L1.
L11 of Title 12. I also want to see the 99A as an acquisition.
The 1099A.
1099A as an acquisition. I think everybody understands the shorthand. Let's see if there's any more questions by anybody regarding this. I have to open up my screen again. See if there's any more questions. Nobody's doing any questions. I'm going to hide my control panel. Okay, so does this kind of a format
This is
only
how you
apply-
challenge a presentment. They're making it. They're trying to. This is like an unlawful detainer. Instead of getting possession of the house, they're getting possession of a car.
Okay.
And I'm challenging their authority to do this. The call reports are listed on the FDIC website. We need to do a separate class for that. I'll show you how to download the FDIC call reports. For any car loan, I pulled this off of the FDIC website.
Okay.
But you need to finish reading this.
Okay, 1099 OID as an original issue discount, and the U.S. Informational Tax Return Form 1096 showing the capital transfer tax withheld and paid out as a taxable termination by the trustee of the transfer and servicing agreement under sections 2511, 2603, 2, 26 small a of Title 26 of the Internal Revenue Code. Otherwise, Infinity is in possession of contraband upon which a lien has attached under 6324 Big C2 in Title 26 of the Internal Revenue Code until the capital transfer tax is paid in full. I want a copy of the RC-S call reports showing Infinity's assets or receivables that were sold or securitized for the first and last quarters of the loan period.
Now you know what assets and receivables are?
Well, that's the promissory notes.
Those are receivables and payables. The payables are what they owe to the depositor. The receivables are what's owed to the bank. That's the difference. And the balance sheet, which is the RCS balance sheet, shows the receivables and payables that were sold or securitized or paid out. It was showed that this was paid in full at closing. This is the same thing as doing an audit on that.
Okay. Schedule RC.
Finish reading it.
Schedule RC-S should be completed on a fully consolidated basis. Schedule RCS includes information on assets that have been securitized or sold and are not reportable on the balance sheet of the report of condition, except for certain on-balance sheet retained interest only strips, which are reported in item 2A of this schedule. Subordinated securities and other enhancements, which are reported in items 2B and 9, and memorandum items 3A, 1, and 2, and seller's interests, which are reported in items 6A and 6B.
Okay, that's talking about credit swaps. What they do is they do put options. In other words, they sell your credit swaps. They sold the credit application is what they did. They treat if you go into 1813 L1, receivables or accounts are money. They sold the account. That's why they don't have the application.
Okay.
The application represents the account or the receivables as to what's owed with the bank. Well, if they sold the account, they don't have an account, do they?
So it doesn't matter if you have an item that you have purchased on credit. Doesn't matter what the item is. It can be a house, it can be a car, it can be a dog, it can be whatever you purchased on credit. You could use this letter to the CEO of the credit company, or if they're taking you into court for a writ of possession or a summary judgment, this is the letter for that kind of situation.
Now, California, notice I put California as the territory of Mexico, was ceded to the United States in pursuance of the provision of the Treaty of Guadalupe Hidalgo on February 2nd, 1848 by Nicholas Trist. President Polk, who sent Nicholas Trist over here as an agent of the executive branch of government, he fired him and withdrew him and told him to come home. So what Trist did is he renegotiated another treaty with the Senate, and he took out Article 9 and Article 10 and Article 11. And what these articles say is that they were supposed to give the Mexicans that were living in California, which was a territory of Mexico, they were supposed to give them their original land grants. And they were supposed to make them American citizens under this treaty. Well, they never did that, because they took those provisions out of the original treaty. So the treaty they adopted is not valid. That's why they're letting all these Mexicans in here, into California, because California is still a territory of Mexico. California was originally owned by Spain. Spain ceded it, and I have that treaty. Spanish succession of California to Mexico. That was called a Spanish treaty. It was ceded to Mexico, and then Mexico ceded it to the United States. But they never fulfilled the provisions of the Treaty of Guadalupe Hidalgo. So California is still a territory of Mexico.
So California is essentially still Mexican.
Yeah, still belongs to Mexico. Why do you think they're letting all these Mexicans come in here?
Huh.
Yeah, there's other states involved. Nevada was involved in this. Texas was involved in this. Colorado was involved in this. You got 7 states altogether that were involved in this Treaty of Guadalupe Hidalgo.
That's because they all border the Mexican border.
Right. And they're all still territories of Mexico. So California is not a state of the Union, because it was never ceded to the United States under this treaty. I can prove that. That's not my opinion. I can prove it. I've got the documentation.
Okay.
Now do you understand why I'm bringing this up? That means that all these California courts are illegal. Every decision that's ever been handed down in California is invalid. Okay, now read what number 6 says.
Okay. That Infinity show any consideration was given to support the contract under Article 2, Sections 2306, and Article 3, Sections 3305 of the California Commercial Code.
Go ahead and read it.
They didn't give any consideration.
Okay, then there's no contract. What are the 3 elements of a contract? You got an offer, acceptance, and consideration. If you don't have any consideration, you don't have a contract. Everybody's asking them, where's the note? You need to be asking them, where's the contract?
Okay.
Okay, now if they, here's how you address the issue. If they say, well, I'm not going to accept your appointment as a trustee, what does this say? This tells you that they have to. Read it.
what this court, as a court of record and trustee under the California Constitution, Article 6, Section 1, under Washington, it's Article 2, Section 4, I believe it is, set up for the benefit of the posterity and sovereignty of the people of the United States of America, lowercase, is required by oath of office and the Internal Revenue Code and the instructions on 1099As and 1099Cs to file a 1099A or 1099C, see page 2, subsection 5A, when there has been a taxable termination as a generation skipping transfer under sections 2611A of Title 26 of the USC. Please fill out and return the enclosed W-9 form in the event that this court, as a court of record, breaches its fiduciary duty to file a 1099A or a 1099C as required above. So I may file the same, showing the court as the recipient of the funds, as a transferee, and liable for the capital transfer tax as a taxable termination.
Okay, so this says 2611 tells you what that a termination is a generation skipping transfer.
And we went over all of that in webinar 312 and 319, I believe.
And page 2, subsection 5A of the instruction booklet on 1099As and 1099Cs tells you that the court has to, the IRS tells you this, not me. The IRS is telling you.
That the court has to file it.
The court is mandated to file it. And what are they going to tell you? You tell the judge, are you telling me that you don't have to obey IRS mandates and that you don't have to file tax returns?
Okay, and does this hold for every court? Because it's in those instructions. It does not.
It says every court administrator has to file this.
It just says courts.
Well, yeah, but the who runs the court? That's the administrator. You need to send a copy of this to the court administrator.
Okay.
Remember, what is an administrator? That's an executor. Administrator and executor, and if there's no administrator or executor appointed, then whoever has actual or constructive custody of the estate property is acting in that capacity. The judge is acting as an executor of the estate because you haven't claimed that. You can't function, you can't come in there into a court and win anything unless you're coming in there as the heir, beneficiary, and executor of the estate of the decedent. And you need to tell the judge that.
So if a judge has recently ruled against you, if you go do this page 2 instructions with a W-9 asking them to give you the 1099As or the 1099Cs with the W-9, with the letter rogatory instructing them to dismiss the case and pay the taxes, that's what people need to do?
Yeah. What does this say? Here's the Constitution. Read that. What does it say? What does it say?
The judicial power of this state is vested in the Supreme Court, courts of appeal, and superior courts, all of which are courts of record.
And what are courts of record set up for? For the sovereignty, for the people. That's your court, not their court. Now, what does this say? Read this.
FAS 95, footnote. Consistent with footnote number 1. Consistent with common usage, cash includes not only currency on hand, but demand deposits with banks or other financial institutions. Cash also includes other kinds of accounts that have the general characteristics of demand deposits.
What is it? Read that again. What does that say?
includes other kinds of accounts that have the general characteristics.
So what they're telling you there is that an account, a receivable, has the general characteristics of a demand deposit account and is the equivalent of cash. So the account that they sold is the equivalent of cash. You should be filing an 8300 form and reporting a cash transaction over $10,000, because most like this car loan was over $80,000. So you should file an 8300 form showing a cash transaction of more than $10,000.
Okay, is there anything else that goes with that 8300 form? Because there were people that did 8300s and they got in trouble and the courts came after them.
Well, you didn't do it. They don't come after me. They jump out the window.
Okay, so what would people do if they were, let's go over that just a minute to make sure that people understand that the 8300 form is anything over 10K.
And all loans are more than 10 grand. I haven't seen a loan for less than that.
Well, sometimes people walk into their bank and they get a signature loan. That doesn't apply?
Well, that's a personal loan. If it's less than 10,000, then you can't report it.
Well, maybe that's where these people were getting into trouble, is that they were trying to report something under 10,000.
Well, I don't know what they did because I haven't seen their paperwork.
I
You didn't do it right. If you do, I don't have any problems. What does this say? Finish reading this. It tells you that accounts are cash items.
In that the customer may deposit additional funds at any time and also effectively may withdraw funds at any time without prior notice or penalty. All charges and credits to those accounts are cash receipts or payments to both the entity owning the account and the bank holding it. For example,
So who owns the account?
the people, but the bank
Well, so you have two things here. You got a cash receipt to the depositor and you have a cash receipt and a cash payment to both the depositor and the bank. Go finish reading it.
Okay. Or payments to both the entity owning the account and the bank holding it. For example, a bank's granting of a loan by crediting the proceeds to a customer's demand deposit account is a cash payment by the bank.
Is a what?
A cash payment by the bank and a cash receipt of the customer when the entry is made.
Now, how can you get into trouble when this is what they're doing according to accounting?
Right, our transcribers, that was all underlined from the beginning of all charges. Okay, so how can you say that again, how can you get into trouble?
Yeah, you're reporting a cash transaction that's mandated by Financial Accounting Standards Board, number 95. You could download the practice right off their website. File it into the court record. Show the judge. Are you know what I tell the judge? Are you telling me that you don't have to file tax returns and that you're in possession of contraband because you haven't filed tax returns?
Well, yeah, this judge yesterday tried real hard to tell me that what I was saying wasn't true. And he got pretty befuddled by the end of the 40 minutes.
Okay, what does this say? This is Schedule RCL, off-balance sheet items. Off-balance sheet means when they take the payables, you have two sides of an accounting ledger. You got payables and receivables. The receivables are what's owed to the bank. The payables are what the bank owes to the depositor, you. And when they take the payables off of the balance sheet, and sell them to somebody else or transfer them to somebody else, that's called an off-balance sheet item. And that's what they're doing. They're selling these accounts as an off-balance sheet item. That's why you have to know accounting in order to deal with this.
Okay.
This judge knew exactly what was going on because when we finish this letter, you'll understand why. He took the case off calendar.
Okay.
And finish reading RCL, off-balance sheet items.
General instructions should be completed on a fully consolidated basis. Schedule RCL-L includes the following selected commitments, contingencies, and other off-balance sheet items that are not reportable as part of the balance sheet of the report of condition, except that the fair values of certain derivative contracts reported in item 17 of this schedule on the FFEIC capital letters 031, 032, and 033.
You know what FFIEC stands for?
Clarify.
Federal Financial Institutions Examination Council. They're the ones that produce these forms that the banks are required to file, and nobody makes them file them except me.
Please say that again. It was a Federal Financial
Institutions Examination Council. All of these forms, those 031, 032, and 033, are on the internet. Just type in FFIEC forms 031, 032, or 033, and they will come up. And you can read the instructions on the requirement that they file. They're not filing any of this stuff.
Okay. Report.
The reason they're not doing it is because they never transferred the funds to the trust or the REMIC, which this goes into.
Okay.
What does it say? I am demanding what?
Among the items not to be reported in the schedule are contingencies arising in connection with litigation. Go over that in just a minute.
Well, they have what they call derivative contracts. That's what they're filing these as contingencies. Means something that's contingent on litigation. They're not required to report that on this schedule, on an RCL schedule.
So they're not.
In other words, contingencies that they sell during litigation are not required to be reported as an off-balance sheet item.
Give us some examples of that.
Well, let's say that they sold something that's related, like a derivative contract, or an annuity contract. You know what an annuity is?
Well, that's usually associated with retirement.
Yeah, it's a charitable contribution. Those are not required to be reported on as an off-balance sheet item.
But that has, so what I'm feeling that I'm hearing you say is that doesn't apply to most of the court documents. In other words,
if they're using it as a charitable contribution, that's how they get all of these Hathaway houses are charitable corporations. They're 501c3s. They're nonprofits.
okay.
They don't file any tax returns because they don't show any profit or gain as income, as taxable income.
Okay. So they don't have to report it on this RCL.
On this, yeah, that's what that means, yeah.
But that doesn't have much to do with most of the people that are being taken into court.
But they have income, and they're not report. What they're doing is making you pay their tax for them. And also, I'm going to show you that as of 2011, the unified tax credit or exemption is up to $5 million
Oh, it went up.
It went up to $5 million on the estate side.
Okay. And so what you do is just start spending whatever you're spending and turning it in to get recouped.
You get recoupment.
Okay, you can't claim that exemption on anything except what you have spent, right?
Well, yeah, you get whatever. In other words, you have an exclusion or unified tax credit, so you have to make over $5 million on the estate side in order to have a tax liability.
Okay, but people are asking, how do you tap into this $5 million? Do you have to go out and buy $5 million, up to $5 million to get it?
Well, you don't tap into it. You use it as a tax credit to avoid paying the tax.
Okay, explain that a little bit.
Well, let's say you have an estate. Let's say you go buy an estate. Let's say you buy a $10 million estate. You can use your unified tax credit as a tax credit. So you'd only have to pay taxes on $5 million, not $10 million.
Yeah, but most people out there like you and me, well, like me, we couldn't qualify 50 cents, let alone 10 million.
Yeah, but the money that they're making off of the REMIC, all this income, they make trillions of dollars that are taxable income that they're not reporting. That's what they're making you pay the tax on. That's why they're doing a forfeiture. They call it a forfeiture. You're forfeiting the property because they didn't pay their damn tax on the capital gains, which is the income that they're holding, and they never transferred.
Okay.
That's why you're asking them for the cash receipt. Finish reading this. I'm demanding what?
Just a minute. I am demanding the cash receipt associated with this account. If Infinity fails to produce said cash receipt, I will be forced to file a complaint with the Securities Exchange Commission as well as the Public Interest Oversight Board, who handle accounting enforcement for the above accounts. Now, what happens if you tendered this information, say, to an opposing counsel or to the other types of situations, and they don't answer it? They don't answer this, and they don't stop. They still continue to come after you. Do we have examples of a complaint that people would do to the Securities and Exchange Commission and the Public Interest Oversight Board?
Yeah, you can file a complaint, yeah.
So people would just Google that. Like if people had put this in, have served it on, say, a judge privately, and told
just like that you sent me that comptroller of currency. They have you file a complaint with them.
With the comptroller of the currency.
Yeah, you file a complaint. You put in the violations, criminal violations, and I know them all.
Are you going to bring that out in another webinar so that we can see what the violations are?
In fact, I'm going to do one.
Okay, so that
they have the criminal charge that they've done is a 7201, income tax evasion. They're guilty of income tax evasion. That's why securitization is illegal. It's because they've never paid the tax on the capital gains that they're holding. They're in possession of contraband. What does it say in 6324C2? That there's a lien attaches until the tax is paid. They already have a lien on them.
Okay.
What do you think they're going to do if you file a complaint with the comptroller of currency?
And that would be
they're guilty of income tax evasion under 7201, and file it with the IRS on that section, on that form 4490. Put that on the 4490 that they've committed 7201 violations,
And
income tax evasion.
And would that be to the Washington, D.C. Comptroller of the Currency?
Yes.
Or would that be...
That's the crime that they've committed.
Or would that be with the local Comptroller of the Currency, maybe of the county or the state that you're in?
Yeah, you could do both of them. File it with the federal, because they're all national banking associations are controlled and licensed by the Comptroller of Currency. That's why they list Bank of America, Citigroup, Citicorp. All of these people, they're a bunch of gangsters. They're going to go down. They're going to bite the big one.
Okay. So if you're still being harangued,
I'm just pouring fuel on the fire.
If you're being harangued in a foreclosure, in the bankruptcy court, nobody's listening, or a state court for driving while license suspended, and they want to claim criminal sanctions of impersonation, and you tell them if they don't stop and they don't settle the account, this is what you're going to do, and then this is what we can do, is to file the complaints with the on the 4490 form with the claim of the 7201 violation, income tax evasion.
Let me ask you a question. Does the Comptroller of Currency, are all Federal Reserve banks national banking associations?
I don't know.
Well, of course they are. Aren't they under the National Bank and Currency Act of June 3rd, 1864?
Well, yes, they have to be.
Okay. Don't they have a security agreement, a deposit agreement, and an escrow agreement with these courts?
Well, yeah, we just pulled out some of those agreements with the, with the Superior Court clerk.
You ought to file a criminal complaint against the court. You ought to do this on this case that you're involved with. You ought to file a criminal complaint with the Comptroller of Currency against these people, these attorneys and this court, that they're guilty of income tax evasion. You want to see how fast this case is? They'll get rid of you so fast they'll get a cold from the breeze.
Well, that's an interesting thing for people that are on the line, our students that have these court situations hanging over their neck for anything. If you've been charged,
if these courts aren't paying attention to you, they'll pay attention to the Comptroller of Currency, because he's the one that regulates the banks, which they're connected to. All these courts are acting as commercial trading companies, and you can bring pressure on them to straighten their goddamn act up.
Okay.
Tell them you're going to file a complaint with the Comptroller of Currency that you're guilty of income tax evasion, because you're a qualified heir who's received property from a decedent's estate, and you haven't paid the tax on it, and you haven't posted a bond for the accountability of the tax under 2032A E11. As a qualified heir, you haven't posted a bond with the Secretary of Treasury for the tax, and therefore you are in possession of contraband.
Slow down a little bit when you're talking about this 2032A E11. What does the bond do?
That bond is a substitution. It indemnifies them against the tax liability. Just like you, when they arrest a vessel in Admiralty, when they put the bond up, the bond is substituted for the vessel.
Okay.
So what that bond does is it indemnifies or guarantees. It's like a promissory note. All a bond is a promissory note.
Okay, so that would
in other words, what they do is they're promising to pay the tax to the Department of Treasury by putting up a bond.
Okay, but what we do when they do that to us, we have to do a bail bond. It's the same thing, isn't it?
Yeah, it's a promissory note. All you have to do is write them a promissory note.
Okay. You know, I think people need to stop warning and start doing.
Yeah, quit complaining all the time. You need to get
Yeah.
zero limits and read it.
If you're in a situation in a foreclosure where they're threatening an unlawful detainer, you just need to go right back in and do these, and not threaten them that you're going to do the criminal complaint. Just do it.
Do it.
And then send them a copy and see how fast your case gets dismissed and nobody bothers you again. There's an avenue that people need to start doing, it sounds like.
That's administrative, isn't it?
Yes, and it's outside of the court.
Yeah. Do you think that's going to bring pressure to bear?
I think it'll bring a lot of pressure to bear, and if you do these criminal complaints against the cops and everybody stopping you on roads that they don't own, and doing these actions against you, and they get these same complaints because they're doing the same thing.
I did this in a traffic case. I was going 100 miles an hour in a 25-mile-an-hour zone. And the cop gave me a ticket. He says, I'm not going to give you he only wrote me up for going 75 because if you go over 80, they have to impound the car. He says, I'm only going to write you up for 75 miles an hour. When I went into court, I went down to the DOT, Department of Transportation, and I wrote a letter to the attorneys. I said, where do you get the authority to force me to get a license? He said, we own the highways. And I said, oh, you do? So I went down to the DOT, pulled the original deed of trust on the stretch of highway. This was clear back in the 1800s, where the people, what they did is they deeded a right-of-way to the Department of Transportation to build a public thoroughfare for the people to use. They didn't deed them title to the damn property. They gave them the right to build a public thoroughfare. So the people still own the land. They're just not claiming it.
Isn't that why they say your property goes to the middle of the road on both sides? Each side gets 50% to the middle of the yellow line.
You own everything. They don't own anything.
Right. We do. As people, we do.
Well, why aren't you telling them that? You know who they had in the courtroom when I went into the courtroom? They had the FBI and the Secret Service in the courtroom on a traffic ticket. You know what the judge did? He says, I'm dismissing this case for lack of prosecution. And the cop that wrote me the ticket was standing in the back of the room. And I started laughing.
So we could essentially do that with most of the cases that we've got going against us.
Right. They don't own the highway. Where do they get the, they don't own anything.
Well, and that's what I said to that judge yesterday, and he about fell off his chair. I said, I conditionally accept your offer of whatever he was trying to say on this criminal charge on proof of claim that you own the highway. So unless you can show that you own that highway, you have to go back to the point of beginning. And
aren't you redrafting him?
Yes, with a conditional acceptance.
Yeah, you're redrafting him. Now he's under contract to you, isn't he?
Right.
You're doing the same thing to him that the courts are doing to everybody that goes in there.
To the people, everything that came out of his mouth and the prosecutor's mouth, I conditionally accepted. And I even did a blanket conditional acceptance on everything they would say throughout that whole hearing. I wasn't going to leave any stone unturned the other day. It was amazing.
You need it. What does this say? It says, read 3311, what it says. Now, this is in all of the commercial codes.
If a person against whom a claim is asserted proves that, 1, that person in good faith tendered an instrument to the claimant as full satisfaction of the claim, the amount of the claim was unliquidated, and number 2, the amount of the claim was unliquidated or subject to a bona fide dispute, and 3, the claimant obtained payment of the instrument, the following subdivisions apply.
Didn't didn't FASB number 95 say that they got a cash payment from me and that I'm entitled to a receipt?
Yes.
Okay, doesn't this apply?
That's what it says. And in some of my situations here, where the amount of the claim was unliquidated or subject to a bona fide dispute.
Okay, finish reading this.
Okay. When you challenge the sufficiency of any court order, is it not an unliquidated or subject to a bona fide dispute? Number B, unless subdivision C applies, the claim is discharged if the person against whom the claim is asserted proves that the instrument or an accompanied written communication contained a conspicuous statement to the effect that the instrument was tendered as full satisfaction of the claim.
Now, doesn't 9-403 and 404 say that they took it subject to your defenses and claims? And don't you have a claim in recoupment and set off that you can assert against them? And isn't that conspicuous statement in there, whether it's written in there or not?
Right.
If you read 9-404, it tells you it's in there, whether it's in there or not.
Right.
Well,
that's what that is.
That's what this is telling you. So it's been discharged, hasn't it?
Okay.
So all you have to do is assert the claim.
Right. Number C, subject to subdivision D, a claim is not discharged under subdivision B if either of the following applies. 1, the claimant, if an organization, proves that A, within a reasonable time before the tender, the claimant sent a conspicuous statement to the person against whom the claim is asserted that communications concerning disputed debts, including an instrument tendered as full satisfaction of a debt, are to be sent to a designated person, office, or place, and B, the instrument or accompanying communication was not received by that designated person, office, or place. The claimant, whether or not an organization, proves, number 2, the claimant, whether or not an organization, proves that within 90 days after payment of the instrument, the claimant tendered repayment of the amount of the instrument to the person against whom the claim is asserted. This paragraph does not apply if the claimant is an organization that sent a statement complying with subparagraph A of paragraph 1. Bring that down to kindergarten level.
Well, this is what it's telling you. Didn't you tender a note to them, and didn't they deposit that note in a demand deposit account and write a check to the seller?
In a consumer transaction, yes.
So you have evidence that the payment was made in full satisfaction, in accord of satisfaction of the debt.
Correct.
I'll go read D.
Okay. I want to bring it back here a minute, though, for clarification. A lot of people online have court issues. How does that apply to a court issue?
Well, if they're bringing a claim against you, doesn't it say in HJR 192 that all debts are discharged dollar for dollar in whatever's legal tender at the time? It doesn't 1-201 define money is not limited to legal tender of the United States?
Explain that a little further.
Well, money is not limited to legal tender.
So, and you can tender an instrument, a private instrument, which carries...
Okay, isn't it a money order? Isn't a money order legal tender?
Yes.
If I do a conditional acceptance and tender a payment, if I do a pay to the order of as a money order, that is a payment.
Yes.
Well,
okay.
they have to accept that as payment.
Okay.
And I got rid of that whole $73,000 judgment on that.
Okay. All right, number D. A claim is discharged if a person against whom the claim is asserted proves that within a reasonable time before collection of the instrument was initiated, the claimant or an agent of the claimant having direct responsibility with respect to the disputed obligation knew that the instrument was tendered in full satisfaction of the claim.
Well, there's your answer right there.
So there's all the bonded promissory notes that we did here a while ago, and the promissory notes that you did at closing, or the promissory note when you got the car. Right?
Right.
Okay.
What is this? Finish reading this.
I am in possession of exculpatory evidence where Infinity sold and assigned, without recourse, its entire interest in the retail sales contract hereinafter receivables as the debt obligations under a transfer and servicing agreement to Nissan Auto Receivables Corporation II, who upon the close of said sale immediately transferred and assigned, without recourse, its entire interest, including the security interest in the receivables, to Nissan Auto Receivables 2009A Owner Trust. These receivables were then securitized as part of a large pool of receivables. Certificates were then registered and issued to investors. By the securitization and sale of these receivables, the enforceability of the original receivable is lost. In order to demand the release of my property and have standing, under FRCP 17A, plaintiff must show that they are the holder of the promissory note under California Commercial Code 3301, 3302, and 3303.
You want to read this? You want to read 30?
I need a little bit of discussion on this, Gene. Like I said, we have to come back and clarify and re-clarify. Does any of this information in this letter apply to courtroom settings?
Yes.
Besides a commercial contract, consumer contract. Say a person is charged with a crime. Does this letter...
They're making a commercial, they're making a demand for payment.
Do the courts also have their pooling and servicing contracts?
Yes. Didn't I tell you that the courts have a security agreement, a deposit agreement, and a escrow agent agreement with the Federal Reserve Bank in New York City? In California, they use Circular 7. In the other states, they use Circular 16.
We've had students this week trying to get Circular 16, and they've taken it out of circulation, or they're not giving it up or something.
Yeah, I've had a real difficult time. I think I've got it on the other computer.
Okay, well, let me put that down on our list for things to go out, which is Circular 16.
You've got an adverse claim on the Circular 16 because they're securitizing your assets, court judgments.
Explain that.
Well, they're taking your like your cash flow payments. You make cash flow payments to these utility companies. They're taking those cash flows and buying mortgage-backed securities with them.
What's a cash flowing payment? Define it and relate it to a court setting. We know
Well,
how it relates to foreclosures and car loans.
when you make mortgage payments on a loan, those are called cash flow claims. The payments that you're making on the mortgage loan are cash flow payments to the investors on a pooling and servicing agreement. So you're paying the investors on their cash flow claim because they're the ones that put the capital up into the trust in the beginning, but they never transferred it, see?
Okay.
So the REMIC doesn't have a claim on your mortgage because
So
they
the
never transferred the funds to the mortgage. They never transferred the funds to the REMIC, so the REMIC didn't have any money to loan you, did they?
No, so the investors don't have a claim.
They don't have a claim. So all this money you've been paying the investors, you can get back because they don't have a claim because they bought a bunch of bogus securities that were never securitized.
And that's
None of this stuff was ever securitized.
And that's what you put on the 7201 criminal complaint on the 4490?
Right. They didn't transfer it under 1.8856-6, subsections A3 of the Treasury regulation. That's Treasury regulations. That governs 856C1 of Title 26, which says they have to file a tax return and a statement to qualify as a real estate investment trust. They never filed a tax return or a statement with the district director in which they're located to qualify as a real estate investment trust. So if they never qualified as a real estate investment trust, they don't have a tax exemption. So they owe a 100% tax on all of the capital income that they're holding, which they have not paid. Is that a crime?
Yeah.
Is that income tax evasion under 7201? File a letter or complaint with the comptroller of currency that these people are guilty of income tax evasion, and you're forwarding CC a copy to the district director of the area in which you're located. Watch out what happens when a blowtorch hits a paper asshole.
Okay.
Okay, we're down on page 4.
Okay. I am a beneficiary, heir, and constituent member of the people of the United States, lowercase, and their posterity under the preamble of the Constitution of the United States of America, lowercase, as an inheritance from the Constitutional Trust. And since I am challenging subject matter and in personam jurisdiction under FRCP 12B1, 2, and 6.
12B1 is subject matter jurisdiction. 12B2 is in persona jurisdiction. And 12B6 is failure to state a claim upon which the court can grant relief.
This court, as a court of record under the California Constitutional Trust, let's clarify that. The California Constitutional Trust is essentially the constructive trust that we've all known about for a number of years. Right?
You have an inheritance as the people. You're part of that Constitution. You're a beneficiary of the Constitution.
Right.
A heir and a beneficiary.
Okay. And yourself, as fiduciary trustees of this constitutional trust, have a fiduciary duty by oath of office to uphold this constitutional trust for the benefit of the posterity and beneficiaries, and an obligation and responsibility to protect my rights, defenses, and remedies, statutory and procedural, as a sovereign of California. You should be aware that I am in receipt and possession of Infinity's 424B5 prospectus, which establishes and evidences the following indisputable facts. Our students want to know, how do they get these 424B5 prospectuses? Because
I can download any of them. You get them off the SEC website.
The
Under the Edgar Archives, Historical Archives.
They have shut it down. They have shut it down. You can't hardly motivate in there anymore.
I can.
I got mine on my house, but I've tried to do ones here recently in the last month or two, and I couldn't find anything anymore.
Well, you give me one, and I'll pull it.
So students, send emails with the name of whomever you're going against, and Gina pull the 424B5 and forward it back to me, and I will forward it back out to you. Okay. Okay, that Infinity is the sponsor and servicer, this is number one, of the retail sales installment contract and note as receivables, and not the owner or original lender under the retail sales installment contract. Number two, that Infinity sold and assigned their entire interest in the receivables to the depositor, Nissan Auto Receivable Corporation 2, under a transfer and servicing agreement, which is depicted herein as a series of flowcharts below. Those flowcharts will be hard to reproduce.
Well, I did it. I'll show it to you. I'm going to show it to you.
That the depositor, Nissan Auto Receivables Corporation 2, then transferred and assigned their entire interest in the receivable retail sales installment contract to the Nissan Auto Receivables 2009A owner trust under a transfer and servicing agreement. And that's what the courts do. They transfer and serve too, right?
Yeah, they do the same thing. They're doing the same thing that they're doing in this.
Only it's all the motion papers and every paper that you sign, right?
Right.
Each one of those papers becomes a receivable under
Right.
the transfer and servicing agreement, right?
Right.
So how can you claim them if there's no money figure on them?
Well, there's always a money figure. Tell the judge you want to see his books. He has his own set of books.
Okay.
Tell the judge you want to see his accounting ledger. Not the clerks, but the judge. The judge has a separate accounting ledger.
Isn't that what the Chris report is?
Yes.
Let's clarify that for some of our students. Chris means Court Registry Investment System.
Yeah, those are the Chris reports. That's part of the deposit agreement, the servicing agreement, and the escrow agent agreement. Tell them you're going to file a claim to the proceeds from the deposit agreement with the Federal Reserve Bank in New York City. But you need to determine which circular they're using. I wrote a letter to this effect. After my case is over, I'll show you this. I'm going into court next month on this.
Okay. Based on the above facts and the securitization of the receivables retail sales installment contract, Infinity does not have enforceability rights as an owner, holder, or holder in due course under sections 3301, 3302, 3303, 3309, and 3418 of the California Commercial Code. Nor does Infinity have possession or control of the receivables or retail installment contract, or a perfected security, I think. Security interest under sections 9310 to 9316 of the California Commercial Code. Therefore, Infinity does not have the right to request possession of the property claimed. I am challenging Infinity's authority to make a presentment without dishonor on behalf of the real parties in interest under Section 367 of the California Code of Civil Procedure and 3501(2)(3) of the California Commercial Code.
Now, you need to read this 3501.
Upon demand, number 2, upon demand of the person to whom presentment is made, the person making presentment shall A, exhibit the instrument. B,
do you ever make them exhibit the note?
Well, we try and try and try.
No, you make them, they have to present the note, otherwise they're not charging you.
Well, the judges, and that's why so many banks are going down. That's why is that not why there's legislation now being drafted that the banks don't have to bring in that note?
Yes, they do have to bring the note if you make a demand for it under this section.
Okay.
Then they can't charge you if they don't make if they're making a presentment, and that's what they're doing. Ask him, say, are you making a demand on me for payment? I have a right to have the instrument exhibited. I'm demanding that you present the instrument. The Uniform Commercial Code says I have that right without dishonor.
Okay.
And if he says, I'm not going to make him produce it, say, well, let the record reflect that they don't have the note. And they're not exhibiting and they're in dishonor, and tell the judge that you're going to do a protest, a certificate of protest on him.
What is a certificate of protest?
A notary protest.
Notary protest.
You want to see him jump out the window? You know what happens if you do a notary protest on him? He becomes liable for the presentment.
So because the notary stands in the same position as a judge, the notary can demand of the judge to bring forth that instrument.
Yeah, you can do a certificate of protest and dishonor for non-acceptance and non-exhibiting of the instrument. And they have to give reasonable identification if presentment is made on behalf of another person. Aren't they making isn't he making a demand and presentment on behalf of another person?
That's what the judge is doing.
Yeah, well,
it
says here he has to give his authority for doing that.
The judge or the attorney?
The judge does. What does it say? Read it. Read B. What does B say?
Give reasonable identification, and if presentment is made on behalf of another person, reasonable evidence of authority to do so.
Isn't that what I'm doing with this judge? Isn't this judge trying to enforce? Isn't the judge making a presentment to me?
Well, yeah, because of the court paperwork against you.
Yeah. And what is it? Finish reading it.
Okay, just a minute. Got to make a note. I'm learning too.
And you tell me the people understand the Uniform Commercial Code?
Number C. Sign a receipt on the instrument for any payment made, or surrender the instrument if full payment is made.
Didn't you make a payment at closing?
Yeah, that's on the promissory notes. They all have allonges.
If you didn't make a payment of the instrument in full, why are you entitled to recoupment and set off as a defense or claim? Answer that question.
Well,
ask the judge that. These are questions you should be asking the judge. Or ask the judge, say, are you telling me that I don't have a claim in recoupment and set off, and that these people are a holder in due course? Because they took it subject to my defenses and claims, and I'm asserting that.
Yeah.
What does it say you can do? Finish reading this. Read number 3.
Number 3. Without dishonoring the instrument, the party to whom presentment is made may A, return the instrument for lack of a necessary endorsement, or B, refuse payment or acceptance for failure of the presentment to comply with the terms of the instrument. An agreement.
Well, aren't they? Doesn't it Aren't they failing to comply with the terms of the instrument?
Well, yeah, because they're not showing that you paid anything.
Yeah.
They're not transferring that and putting it into the REMIC and into the REIT with the deed with it to get the election, and they can't do that until they file the tax return.
Right.
And it has to be comply with the terms of the instrument and agreement of the parties or other applicable law or rule.
So can't you challenge their authority to make a presentment if the note was unsecured at closing because they never transferred the funds to the REMIC and there never was a loan? Can't you demand that they produce the CMIRs, currency, money, international reports, transportation reports under the Bank Secrecy Act and the Patriot Act that shows that they transferred the funds to the REMIC? Can't you make them produce the statement and the tax return that they allegedly filed to take the election to treat the property as foreclosure property? You bet your ass you can. You can do it under the Patriot Act. What is that court operating under? Aren't they operating under the War Powers Act of 1933, which is the Emergency Bank Act of June 5th, 1933? And don't you have a right under the War Powers Act to exercise your rights under the Patriot Act and make them produce the source of the funds which funded the transaction?
And that's who you make the claim to the currency of the comptroller?
Yes.
Under that 2501. So now you would not only put 7201, you would put 3501 too.
Yeah.
Because they're not doing it. Right?
Yeah, they're not doing it. Right.
Now, does each of those sections that you put down there carry all the penalties of the 4490 section 856?
Right. And the 3949A.
And the 3949A. Okay, explain how the 856 will apply to a mortgage foreclosure and not necessarily it applies in a
because under 856C1 under section 856C1 of Title 26, they have to take an election to treat the REMIC as a real estate investment trust in order to get the tax exclusion so they don't have to pay income tax on the payouts to the investors. They never transferred the funds to the REMIC and they never filed the tax return to get this exclusion or election. And it says that they cannot treat the property as foreclosure property under 1.856-6, subsection A, subsection 3 of the Treasury regulations, unless they take an election to treat the property as foreclosure property, or if the forfeiture or default, if a default is imminent. Why is the default imminent? Because they never transferred the damn funds to the REMIC in the first place.
So they can't come after you until and unless that is done.
Until that's done, the loan was in default at closing because they never transferred the funds to the REMIC to create a mortgage loan. So the loan was in default and unsecured at closing. That's why they never took the election to treat it as foreclosure property, so they can't foreclose on it. And sections 1212 of Title 26 says that's a prohibited transaction because the foreclosure property was not declared to be foreclosure property. So it's a prohibited transaction. They can't do it.
Okay.
That's another thing. You can file a claim. You can file a complaint with the with the comptroller of currency.
Okay.
You can bring all this. You can file it with the IRS. So I filed. You can do one with the IRS and with the comptroller of currency. Give them the double whammy.
And that wouldn't that go to the attorneys, the court, the judge, and the sheriff, and
Yes.
everybody that took a house away from you?
Right.
And
They've committed crimes.
And so even if you were stopped with a traffic ticket and they impounded your car, would that not apply?
Yes.
Now, let's go back on this 856. Sometimes you told me that it has a character to apply to foreclosure properties, but a different character when it's applied to maybe a court setting or
Well, the difference is that in a mortgage, you're directly involved in a real estate investment trust. At least that's what the B5 prospectus says. And they did that to get the exclusion from a tax liability. So if they didn't have a real estate investment trust involved in it, then they have a huge tax liability. And they were required to file that within 30 days after they acquired the property. The trust is, the REMIC. So if they didn't file the return, then whoever created this trust, the depositor or the servicing company, has a 100% tax liability. And there's a $50,000 penalty for each violation of this. It says that in 856.
That's an 856 applicable to a foreclosed property. Now, did you not tell me that 856 applies in a little slightly different character to your courtroom settings?
Yeah, if they do a deposit agreement, then you do have a real estate investment trust.
So you have.
But again, they're not setting up a real estate investment trust. Tell them you want to see the B5 prospectus and the name of the trust on the deposit agreement.
Okay.
If they don't produce it, then they don't have it, do they? So they owe all the tax on it. There's no REIT involved in it, so they owe 100% tax penalty on it because they haven't filed a tax return and paid the income tax on all this income that they're holding.
Okay, but let's bring this down so that people can understand. The deposit agreements are also done by Superior Court by the court clerks.
Right.
And they also have escrow agents.
Ask them. Tell them you want a copy of the, tell the clerk. Go to the head clerk and tell them you want a copy of the deposit agreement with the New York Federal Reserve Bank. And you want a copy of the service agreement, and you want a copy of the escrow agreement. You want to know who the escrow agent is.
Okay.
Because you're going to make a claim on the proceeds. Watch how fast they get rid of your case.
Okay. So, again, how can we take this information on the Form 4490?
Well, that's because they haven't. You need to send that along with this letter to the IRS and have them fill it out. Say, I'm filing a claim that these people are in possession of contraband, that they're in possession of proceeds that they haven't paid the taxes on, because they haven't transferred the funds to the REMIC, and they haven't taken the election to treat the property as foreclosure property. That's number 2. So they did a prohibited transaction. They can't foreclose on the property unless they do this.
And that property can be your body, your car, anything.
Yeah, it can be a car, house, anything.
So if they took you to jail, now they've done a 1212 violation, a prohibited transaction. right or wrong?
Well, they're not, if they haven't paid the tax on it, yeah. Indirectly they are, yeah, because they haven't paid the tax on they're acquiring property. That's what the judge is doing. The judge told him, he says, well, she's making a claim. Well, you know what you should have said to the judge? Well, you're conspiring with her. You're the one that's enforcing it. So I'm holding you liable. He's trying to lay it off over onto her. He's the one that's making the decision, not her.
Oh, she definitely, the chair should have split in two. It was funny.
Yeah, well, yeah, way you get good at this shit. They'll be jumping out the window.
We're learning.
Tell them you got a parachute for them so it will break their fall.
Let's see if there's any more questions on the board. And my question thing hasn't been working, so I don't know why it's not working. Let's see if there's some more questions.
You got to be able to think you got to be spontaneous. You got to be able to think off the top of your head. That's why you got to know all this stuff without writing it down. You got to know all this stuff off the top of your head.
Yeah, we have to practice in front of the mirror or hold mock practices with people being judges and attorneys and role play to get this in our head.
Okay. Finish reading this, and you'll have a better understanding.
The transfer and servicing agreement evidences or establishes all four elements of an investment contract. This is evidenced by the facts that the promissory note and the security agreement contain all the elements, terms, and Whoops. You went clear to the top.
Yeah, my screen went out.
I'm back at page 1.
Okay. We'll start here, page 6.
The transfer and servicing agreement evidences or establishes all four elements of an investment contract. This is evidenced by the facts that the promissory note and security agreement contain all the elements, terms, and substance of an investment contract and demand deposit agreement in the form of a commercial transaction as outlined in Reeves, R-E-V-E-S, versus Ernst, E-R-N-S-T, and Young at 494 U.S. 56, 1990, and Perrysburg, P-E-R-R-Y-S-B-U-R-G, T-W-P versus Rossford, R-O-S-S-F-O-R-D, at 103 Ohio. Is that State 3rd?
Yeah, it's the state reports.
State 3rd, 79.
TWP means township.
Okay. Perrysburg Township versus Rossford, 103 Ohio State 3rd, 79, 2004 to Ohio 4362. Following the Reeves case cited below, and form was disregarded for substance and emphasis was placed on economic reality. An investment contract thus became to mean a contract or scheme for the pledging of capital or laying out of money in a way intended to secure income or profit from its employment.
Isn't that what they're doing in the courtroom?
Laying out of money in a way intended to secure income or profit.
Yeah, isn't that what they're doing?
Well,
What do you call a deposit agreement, a servicing agreement, and an escrow agreement?
Yeah, with the court.
Isn't that the placing of capital or laying out of money in a way intended to secure income or profit? And where's the capital coming from?
From the people in all the fines and everything.
Yeah, duh.
Right.
Don't you have a claim to that?
Yes. State versus Gopher, Gopher, Tire and Rubber Company, 146, Minnesota, 52, 56, and at 177 Northwest, 937 to 938. This definition was uniformly adopted by state courts to a variety of situations where individuals were led to invest money in a common enterprise with the expectation that they would earn a profit solely through the efforts of the promoter or of someone other than themselves.
Isn't that what they did with you? Didn't they use misrepresentation to get you to invest money so that in a common enterprise with the expectation that they would earn a profit?
Yeah, well, that's where you put your bail up. That's where bail comes in at, especially.
Well, sure.
Okay, and that's under Securities and Exchange Commission versus W.J. Howey, Howey, Company, at 328 U.S. 293 in 1946, and not a loan or retail sales installment contract. I am therefore denying the authenticity of the signature under Section 3308 of the California Commercial Code and Sections 1400 to 1402 and 1410 to 1414 and 1450 to 1454 of the California Evidence Code. Infinity must produce the original retail sales installment contract with an original signature.
You notice I'm not demanding that they produce the note. I'm demanding that they produce the contract.
Right.
What contract?
That's the application. That's the application.
Did it work? You bet your ass it did. Read this. I'll read this. What does this say?
3308. In an action with respect to an instrument, the authenticity of and authority to make each signature on the instrument is admitted unless specifically denied in the pleadings.
Say that again. Read that again.
Unless specifically denied in the pleadings. If the validity, go ahead.
Well, go ahead, finish reading.
If the validity of a signature is denied in the pleadings, the burden of establishing validity is on the person claiming validity. But the signature is presumed to be authentic and authorized unless the action is to enforce the liability of the purported signer and the signer is dead or incompetent at the time of trial of the issue of validity of the signature.
Isn't that all capital letter name dead?
Yes.
And isn't he incompetent?
Yes.
Well, then is the signature valid?
Is presumed to be authentic and authorized unless the signer is dead or incompetent at the time of trial on the issue of the validity of the signature. If an action to enforce the instrument is brought against a person as the undisclosed principal of a person who signed the instrument as a party to the instrument, the plaintiff has the burden of establishing that the defendant is liable on the instrument as represented person under subdivision A of section.
You can deny. You can say that the signature was forged. You need to read People versus Martinez. It's a 2008 Supreme Court decision out of California. If they use misrepresentation to induce you to sign loan documents, the signature is forged if they use misrepresentation.
Well, they misrepresent all over the place.
Well, then it's a forged signature.
Right.
Well, you should deny the authenticity of the signature. They can't get around that.
And that's under Martinez?
Yeah, People versus Martinez.
Do you have the citing for that?
Yes, I do. Let's finish reading this, and I'll get it for you.
Okay. 3402B. If the validity of a signature is admitted or proved and there is compliance with subdivision A plaintiff producing the instrument is entitled to payment if the plaintiff proves entitlement to enforce the instrument under Section 3301, unless the defendant proves a defense or claim in recoupment.
What does that say?
Unless,
So if you make a claim if you make a defense in recoupment or set-off, then they can't enforce the instrument. They can't foreclose on it.
okay, and it says here the right to payment of the plaintiff is subject to defense or claim. Wait a minute, I skipped it. If a defense or claim in recoupment is proved, the right to payment of the plaintiff is subject to the defense or claim, except to the extent the plaintiff proves that the plaintiff has rights of a holder in due course, which are not subject, my screen went off, which are not subject to the defense or claim.
So if they took it subject to your defenses and claims, they're not a holder in due course. So they don't have enforceability. That's what this is telling you.
Okay.
And isn't that what 3305 subsection C says? If there's no holder in due course, the obligor is not obligated to pay on the instrument. Hello?
So that's another section for this 4490 form.
Yes.
So that's 3402.
B.
What was the other one? 3308 was a forged signature, and 3402 is what?
3308 is the authenticity of the signature.
Right.
3402 is a claim in defense and recoupment.
Recoupment.
And 3305 subsection C.
Which is what?
Uniform Commercial Code. It says that if there's no holder in due course, the obligor is not obligated to pay on it. We'll go there in a minute. I'll show you.
Okay. Well, we're coming up on 8:30 now, Jane, so.
Well, let's finish this up. We only got...
Okay. The transfer and servicing agreement evidences or establishes that Infinity is trying to enforce the following contracts or agreements: purchase agreement, sale and servicing agreement, trust and indenture agreement, which have not been memorialized or subscribed by me under Section 1624A of the California Civil Code and the Statute of Frauds, which are unenforceable as they do not apply to me. I am sure that you are aware that credit is not sufficient consideration to support a contract under Article 2, Section 2306, and Article 3, Section 3305 of the California Commercial Code.
Yeah, go ahead.
You got to move it up a little bit.
I'm giving a class. Can I call you back? Okay, go ahead. Go ahead.
Move it up a little bit. (2306) A term which measures the quantity by the output of the seller or the requirements of the buyer means such actual output or requirements as may occur in good faith, except that no quantity unreasonably disproportionate to any state estimate or in the absence of a stated estimate to any normal or otherwise comparable prior output or requirements may be tendered or demanded. Number 2, a lawful agreement by either the seller or the buyer for exclusive dealing in the kind of goods concerned imposes, unless otherwise agreed, an obligation by the seller to use best efforts to supply the goods and by the buyer to use best efforts to promote their sale.
So they never gave you any consideration. They never supplied the goods or movables to
Right.
support a contract.
Okay. So what would be the goods in a court setting?
Well, it'd be the, what was the bargain for consideration? They never loaned you anything.
Well, a courtroom setting doesn't loan you anything. If you're in a criminal situation.
Well, you don't have a contract with them then, do you?
Then they can't enforce anything criminally because there's no contract.
Right.
So
Tell them you're not going to contract with them.
Okay, so 2306 would go on a 4490 form because there's no contract.
Yeah.
Okay. Infinity's contract violates Section 8 of the National Bank Act of June 3, 1864, wherein only lawful money based on personal security may be loaned. See also Title 12, Section 24, Paragraph 7 of the USC. So I am challenging the validity of any alleged debt under Article 1, Section 10 of the Constitution of the United States in its entirety under the Fair Debt Practices Collections Act of Title 15, Section 19, 1692 et sec, and Title 31, Sections 5118 D2 as their alleged retail sales installment contract violates public policy.
Doesn't it say in ACR in 5118 D2 that no contract or obligation shall contain a clause which purports to give the obligee the right to demand payment on any specific coin or currency of the United States? And doesn't it say that it shall be discharged upon presentment dollar per dollar in whatever is legal tender?
Right. So there's another thing on the 4490.
It was discharged under public policy, according to ACR 192.
Right. So that means that this Title 15, Section 1692G is a violation of public policy. Right?
That's why you can challenge the validity of any debt, and if they don't prove, they can't prove the debt because there's no money.
Right. Okay.
Well.
But that still becomes, it's not only 1692G, but it's also 5118.
D2.
Okay. The above evidence and documentation means Infinity's documents have been materially altered by endorsement which discharges the drawer and maker under sections 3407, 3414, and 3415 of the California Commercial Code as a suretyship defense. Okay, so then here's another section on the 4490. So folks, see how we're doing this? Wait a minute till I get down all
what is, read B here. Don't they endorse it without recourse?
Tell me, go back up just a minute so we can write down those three numbers. Just go back up for 10 seconds. The last sentence, yeah, one more line, okay. 3407, 3414, 3414 and 3415 would be a surety ship defense violation?
Yes. They've impaired your obligation by materially altering. They did a loan modification at closing without your consent.
Right. Yeah, because they altered your note behind your back.
Yeah, didn't they make you undisclosed third party to a pooling and servicing agreement?
Right, because they didn't tell you.
Right.
Okay, 3415A. You want me to read B? If an endorsement states that it is made without recourse or otherwise disclaims liability of the endorser is not liable under subdivision A to pay the instrument.
Well, didn't they endorse it without recourse?
They did. But
yeah, but that discharges the drawer and the maker.
So they endorsed it without recourse. So this says the liability of the endorser, but that's not me, it's them.
No, it's you. If you're the drawer and the maker, you're the endorser. Didn't you endorse the note?
Yeah, I signed the note.
Well, you endorsed it. That's what when you sign it, you endorse it.
Okay.
So if I materially alter the note by signing it without recourse, that discharges you.
Okay.
You're an endorser, aren't you?
Yeah, because I signed the note and gave life to it.
Yeah.
Right?
Yeah.
Okay.
Now here's the flow charts. I wanted to show you these. I took these off the B5 prospectus and incorporated them into this letter. Can you see them?
So this chart was on the B5 prospectus?
Yeah.
Or in it?
Yeah, or in it. And I did a copy and paste.
Okay.
And put it in this letter.
Okay. Do all B5 prospectuses have these flow charts?
Most of them do, yeah.
That's why the crazy document's 1,000 pages.
Huh?
That's why the B5 prospectus documents are many times 1,000 pages to 1,500 pages.
Yeah, I've seen them up. Yeah, I've seen them 400 or 500 pages.
I know when I pulled this prospectus on my house, it was over 1,000 pages.
Okay, you know the trustee. Notice who the trust is. In the indenture, here's the trust, but they never transferred the funds to the trust.
Okay.
Well, so what did? They never. So they can't foreclose on it, did they? You see, I didn't bring this up because at the time I did this letter because I didn't know all this. This is stuff that I found out later on. I would have brought that up in here.
So the Wilmington Trust Company and the U.S. Bank National Association are the servicers.
No, they're the owner-trustee. They're the trustees of this trust. Here's the trust. This is the issuing entity that issued these notes, the Class A1 notes, which are certificated securities. A1, A2, A3, A4.
Okay.
And they issued them to the depositor, which is Nissan Auto Receivables.
And who's the depositor?
The depositor is Nissan Auto Receivables. See, it says right here, depositor. It tells you who they are. Here's the issuing entity. Here's the depositor. And here's the sponsor and administrator. Now, what is an administrator? Isn't that the same thing as an executor?
Yes.
Okay, and here's the servicer and sponsor, see?
Which is, speak what you're pointing to so that the transcripts can be a little better understood.
Well, it says Nissan Motor Acceptance Corporation is the servicing, sponsor, and administrator
And
of
then,
all this.
so that was created by Nissan Auto Receivables, which is underneath them as a depositor.
Yeah.
And where does Nissan Auto Receivables owner trust was created by Nissan Auto Receivables, right?
Right.
So you have to go from bottom to top. And then over on the right is the trust company, which is a trustee, Wilmington Trust Company, which is the owner trustee, and U.S. Nationalist Bank National Association is the indenture trustee.
The judge took this case off of calendar.
Now, what is this on the right where it said available?
This shows you available amounts to the servicer. Servicing. This is a flow chart.
Okay.
It shows you where the money's being dispersed to. In other words, all these investors that bought these Class A notes are all worthless because the funds were never transferred to this trust.
So the trust had to be on the left of Nissan Auto Receivables?
Yeah, this trust never got the funds, so these notes as certificated securities are all worthless.
Okay.
So all these investors that bought these notes bought worthless securities.
So where's the trust at? The owner trust here, Nissan Auto Receivables?
Yeah, this right here is the trust.
Okay, so what did not go into there?
The note, the installment sales contract in the note.
Okay, so it's not listed on this flow chart. That's where you can say they don't have it.
Right.
Okay. So
they're not the owner, are they?
We got to speak a little more definitive for our people that are only going to read the transcripts.
I'm going to go down to page 3 now.
Okay.
Or page, this is 9 of 11. Here's the rest of the flow chart. Whoop.
Go up. You went a little bit too far up.
There's the rest of the chart.
Okay. You want to explain some of that?
Okay. Well, now who was the depositor? It shows the depositor, the servicer, payments on receivable. See, they made the payments and they bought all these certificated securities, but they never transferred the funds to the REMIC, to the trust. So all these investors bought worthless securities. So they're going to have to give them back all their money. You think they're not going to drop this? You think they want this you know what would happen to all these banks? Every bank in the United States would go belly up. Because they'd have to give all this money back to the investors because they bought worthless securities. Do you think they want this out?
It would be interesting for somebody to take these charts and take Nissan off and make it a generic term that everybody could attach to a 4490 form.
Well, you could do that. You could just type the names in there.
Yeah.
What you could do is just write a letter and then send it to the IRS and tell them to fill the 4490 out.
And you don't have to claim anything on it?
Well, this is on. They don't have a claim. Here's how I ended the letter.
I am conditionally accepting Infinity's demand to surrender possession of the 2009 Infinity VIN number on proof of claim that there's been ratification of commencement by the real parties in interest under the transfer and sale agreement, and that Infinity has registered title ownership of the retail sales installment contract receivables as the debt obligation. Infinity is, number 2, Infinity is the lender in fact. Number 3, Infinity is the holder in due course. Number 4, Infinity has not securitized the retail sales installment contract receivables, thereby making it unenforceable. Number 5, Infinity is not violating public policy by demanding payment in any specific coin or currency. Number 6, Infinity did not receive payment in full in the form of numerous bankers' acceptances and Class 2 government-issued securities that were authorized for set-off through GSA SF-28, OF-90, and
That means optional form.
Optional Form 90, and OF Optional Form 91.
That's a release of lien on property, and 90 is release of lien of property, and 91 is release of lien of property in escrow.
Okay, as well as written authorization for use of said securities to set off, settle, and close this account. Infinity did not dishonor me by accepting payment and refusing to ledger account balance to zero. They did dishonor you.
I know they did.
Yeah, but you did not dishonor you. Might want to fix that.
Yeah, they did. Well, Infinity did.
Oh,
they didn't settle and close the account.
Yeah, you're saying that to prove that they did not. Okay. Number 8, that Infinity has not monetized, altered, or endorsed in any of the payment instruments without recourse that were presented by me regarding this account.
This is the person that I did this. She still has her car. In fact, I'm driving the car around.
Okay. So let's bring this back down to a courtroom setting, because 90% of the bleeding out there is courtroom settings.
Okay, read this, how they served this.
Proof of service.
She's a notary.
Being of 18 years of age and not a party to this case or action, certify and declare the following, that I served a true and exact copy of this letter for conditional acceptance of Judge David R. Worley's summons and notice of application for writ of possession, and the alleged legal counsel at the address below by certified mail with delivery confirmation, by depositing in the U.S. mail postage prepaid at Thousand Oaks, California on Tuesday, 5/25/2010. Now, let me tell you, if you do, what I have found out recently is that certified mail can be refused even with a delivery confirmation. And so if you just do delivery confirmation, you get your tracking, they say it's delivered and they can't refuse it.
Yeah.
So I've learned that I don't like certified mail. I like delivery confirmation.
Yeah, that's what I do, yeah.
All right. We have gone almost an hour over tonight, Jean. I think that everybody, you had one more thing that you wanted to show after we got done reading.
What do you want me to show you? You want me to show you, oh yeah, 3305. I'll show you, let's see. What does that say right there?
An obligor is not obligated to pay the instrument of the person seeking enforcement of the instrument, does not have rights of a holder in due course, and the obligor proves that the instrument is a lost or stolen instrument.
How come you're not bringing that up?
In the foreclosures and all consumer credits?
Yeah. Isn't that what it says?
Okay, yes, because you can claim they don't have rights of the holder.
See what it says? 3-305, defenses and claims and recoupment.
Uh-oh. I'm on the phone. Bye. Sorry about that, guys. My phone's going to tweet again if I don't turn it off. Okay. And that would be in a courtroom setting, too, where there's no rights of a holder in a courtroom setting. Right?
Right.
Okay. And okay. We just read that, didn't we? 3-305C.
They don't have the rights of a holder in due course. They have no enforcement.
And that's another section that's a violation on the 4490.
Yep.
And that goes for any order of the court, too. Right?
That's right. Aren't they seeking enforcement?
Yep. So,
Arrest-
as in my situation with my son, the enforcement of child support, maintenance, and attorney's fees all fall under this 3-305 because
Yes.
it's not a holder in due course.
What's your first clue?
Explain it.
Well, they're not a holder in due course of the instrument.
And that would be the court order?
Well, the child support.
Who's-
Where does he get the authority to order you to pay child support? He's not even involved in this thing.
Right, it's between the wife and the husband and the kid.
Yeah.
Okay, so
How come you're not bringing this up?
explain that just a little bit further so people can understand how it might apply to a criminal case in a court, child support, or courtroom setting.
Well, if they're not a holder of the instrument, and didn't they take it subject to your defenses and claims?
Well,
Let me ask you a question. Under HCR 192, don't you have a right of recoupment or set off because they took all your money?
they're taking it, yeah.
Well, don't you have a right to recoupment and set off?
But doesn't the court clerk claim that they're holder because they have the original instrument?
Well, make them produce it then.
Well, it's in the court file. They put all the original things in the court file.
Yeah, well, make them produce it then. What instrument are they seeking enforcement of?
The marriage license.
Well, no, they're seeking enforcement of payment of child support.
Yeah, but how does that apply to the instrument?
Okay, where's the instrument that says he has to pay child support?
Usually a original order signed by the judge, not embossed.
And where does the judge get the authority to force him to pay anything?
Well, that's the true issue. Then there is no instrument. There is no enforcement.
Well, then he's not obligated to pay it, is he?
There's no valid original instrument. Would that be a better way so that it's not confusing?
Right, and the court is not a holder in due course.
Okay, now that makes more sense.
Tell him you have a defense in recoupment and set-off, and you're using that as a defense to the claim.
Okay.
And you're authorizing him to do the set-off. Recoupment means counterclaim. You have a counterclaim.
Okay.
Isn't the HAR 192 a replevant bond? Tell him you're using HAR 192 as a replevant bond. It's discharged upon presentment, dollar for dollar.
So what is HJR 192?
Tell them it says any obligation that contains a clause. They're trying to make you pay an obligation, aren't they?
Yeah, but what did you just say HJR 192 was? Some kind of a bond?
Replevin bond.
Replevin bond.
We
Okay.
need to have a class on redemption. You guys don't understand redemption.
Well, you're just saying the terms, and everybody listening and everybody participating needs to have these terms clarified so that when they're listening, it will make a picture.
Okay, we'll go over what a replevin bond is next. We'll go over it next class.
Okay, I'll put that on my list here, replevin bond. And with that, Gene, we are out of time. We are an hour over, so everybody really got their money's worth tonight. With that, folks, we'd like to say thank you. The questions did not come through. I'm apologizing, but I don't know why they didn't come through. But I want to say thank you. I'm so grateful for each and every one of you. We love all of you, Jean and I do, and everybody needs this information so much. I just want to say thank you to each and every one of you. Closing comments, Jean.
I love you all. Study and read. To show yourself approved unto God, a workman that needeth not be ashamed, but rightly dividing the truth. All Scripture is God-breathed, given for reproof, for instruction in righteousness, that the man of God may thoroughly furnished unto all good works, a workman that needeth not be ashamed, but rightly dividing the word of truth.
Thank you, everybody, and good night. Let's stop the recording.